Right, good morning, everybody. It's 11 o'clock on the 9th of August. It looks like it's going to be a beautiful day, so we'll press on with the meeting in front of us. We'll start, please, with apologies.
Yes, thank you, Chair. I've received apologies from Councillor Trowbridge, Councillor Waring and Councillor Williams. Thank you.
Thank you very much. Has item number 2, has anyone got any declarations of interest on the agenda? No? Okay. Item number 3, please, is the minutes of the meeting held on the 19th of April 2024. You've all had a copy. Okay, thank you. I'll just grab a pen. Thank you very much. And item number 4, please, is update on definitive map modification order backlog. Who's going to take this?
I'll take that, Chair. Thank you.
Okay, thank you.
Morning, Chair, members. This report is to update the panel on the current position in respect of the backlog of undetermined definitive map modification order applications and directions from the Secretary of State, together with an update in respect of the later stages of the process following determination. Members will recall that the last update was in December of last year, and this update was due in June. However, due to the general election, the June and July panel dates were cancelled, and so this is the first opportunity to bring this update. So as you can see from the report, the county still has a significant backlog of undetermined applications, which currently stands at 277, including 46 on which the council has been directed by the Secretary of State to determine within a specific time frame. The council also has a backlog of 89 determined applications for which a modification order needs to be made and published for each of those applications. Since 2017, the council has received 157 new applications and has been directed by the Secretary of State in respect of 169 applications. It has determined 125 applications. These figures are set out in the table on page 2 of the report, which shows a breakdown of those figures for each year since 2017. What the figures show is that the county has received a considerable number of new applications since 2017 and shows a trend from 2020 to 2022 which saw more new applications than determinations. However, the more recent figures from 2023 and so far in 2024 shows a reduced number of new applications with more determinations than new applications. However, the backlog still remains high. The number of directions received was very high for the period between 2017 and 2020, although this number has reduced over the last 3 years. During the last 3.5 years, the county has determined more applications than directions received, and so the number of directed applications has decreased over the last 3.5 years and continues to reduce. That said, there is still a considerable backlog of outstanding directed applications still to be determined. Also set out in the table below are the figures for each year in respect of the making of definitive map modification orders resulting from determinations, together with the number of appeals against a refusal to make an order, the number of contested orders, many of which are yet to be concluded and some of which may result in public inquiries. The report, which was presented to the panel on the 23rd of June, proposed 3 new measures to assist, 23rd of June last year, that would be, proposed 3 new measures to assist in reducing officer time spent on application process, and these are set out in paragraph 27 of that report. The first of those measures was an increased use of delegated powers, which was introduced with immediate effect. The delegated powers currently in place only allow for those matters which the local county councillor and the Director for Economy, Infrastructure and Skills consider appropriate to be dealt with by way of delegated powers, which would generally amount to non-contentious applications. Since June 2023, there have only been 3 applications which have met that criteria. 2 of those have been determined and 1 is pending determination, and you'll see that the 2 that have been determined are actually on the agenda for information of members. The second and third measures were to be implemented once processes involved were considered to be sufficiently robust. These measures being a resolution of applications by way of alternative means and the use of digital solutions for application packs and informal consultations. A small number of applications may be eligible for alternative resolutions and work is ongoing in respect of those. Work is still ongoing in respect of digital solutions and I'll report again on that in the next update. Okay, thank you, Chair.
Thank you very much. Paul.
Chair, is there any way we can lower the decision-making body so we can delegate more in a way, really? So at the moment it's got to be the county councillor and the cabinet member, etc., or the director for so-and-so. So we can get more go through that system because, okay, we're clearing the backlog, but perhaps not as speedily as we could. I mean, I don't make the decision today, but look at yourself, perhaps, Chair, with the corporate director to see if there's any way we could make it easier for matters to go to delegation as opposed to need to come here.
Do you want to make comment first, and I'll comment as well, please?
It would make it easier if those restrictions were removed from the delegated powers, and we do think that that's the reason that we haven't actually been able to make many delegated decisions, because we do need those consents in place in order to be able to do so. And that isn't necessarily always easy to get, unfortunately. So if it was, were you proposing the chair with the director? Yes. Yeah, I think that might make things easier.
Okay. And now as far as a statement from me as being chair, I would welcome anything that could decrease the backlog. And if this is one of those avenues to go down, that's fine with me. However, to me, it's always, as long as it's safe in terms of the decision-making process, and it's safe in terms of the Staffordshire County Council, those have almost got to be the two protocols that we cover off.
You have to go to full council to do it. Like, we have to make that decision. But I mean, you working with the main body, I think we could sort something that could go to council.
Thank you. It would need to go through the various processes in order to be able to change the delegated powers. But obviously, that we can put that into place if the chair agrees.
Is that it then on that? Oh, David, sorry.
Quick point. On the risk implications, we say that there's no risk, but in fact, our failure to determine an application does create a risk, doesn't it? So we could have a financial liability if we fail to determine an application. And we have appeals or whatever else. I mean, we have an example of where that's happening, not because we failed to determine something, but the costs of going to the courts, that there is a risk as far as we're concerned if we don't get on with reducing that list. Yeah.
Yes, that's correct. There are risk implications. The risk implications specifically to this report, it's just an update report and there weren't any risk implications associated specifically with the report itself. Clearly there are risks with the work, which we are all aware of, if we don't determine within various timescales. And those are all set out in the other reports, the individual reports that are brought.
Okay, thank you for that. And we'll move on, please, to item number 5.
Sorry, Chair, do we need to note that report?
Does it?
The panel received and note the report. I'll move that, Chair.
Okay. Okay. All in favour? Okay, thank you for that. I'm having problems with my computer. I was just trying to get it to actually show me what I wanted to see. So we will move on now on to item number 5, which is Wildlife and Countryside Act 1981, application for the upgrade of a public footpath 1A from Waterhouse's Farwall Lane to Slade House. And Hannah, are you going to take this one?
Yes, thank
Thank
you,
you.
Chair, members. So this is an application as stated to upgrade public footpath 1A in the parish of Waterhouses to a restricted byway. The application was submitted by Stafford Moorlands Bridleways Group, and it was submitted based on historical evidence. The evidence originally submitted with the application consisted of a document requesting a repair to the highway called Cartlow Lane, dated 1900, with an accompanying map, and also a copy of an outdoor leisure map. Further evidence was also submitted consisting of tithe maps, documentation relating to the Local Government Act 1894, OS maps, a 1910 Finance Act map, and a parish survey card. The route itself to the north connects to the G414, which is a green lane and a highway maintainable at public expense. It was previously on the definitive map as Public Footpath 95 Waterhouses, prior to it being classed as an all-purpose highway. This is, however, a separate route, and it does not form part of Public Footpath 1A, although it does connect to it. So if I turn first to the evidence, so in relation to the document requesting a repair to a highway, this document is made pursuant to the Local Government Act 1984, and it was served on an individual, Mr. John Ratcliffe, requesting him to repair a highway that was deemed to be in his occupation. So the highway in question is called Cartlow Lane. So under the Local Government Act 1894, Section 25 transferred responsibilities, including maintenance responsibilities for highways, to rural district councils. This section of the Act also gave rural district councils the powers to serve notice on individuals they deemed liable to repair highways. This type of document is a record of maintenance responsibility. It is not necessarily a record of the nature of any rights over a way. So the map accompanying the document shows a route depicted along the line of the mid to northern section of the applied for route as two broken lines connecting to Slade House in the north, and the route is braced to field number 34. The southern section of the route is also depicted as two solid lines. So this documentation supports the physical existence of the alleged route and that the route was considered to be public. However, the document does not provide any evidence as to the nature of the rights over the alleged route. The term highway is a generic term. A highway can be a way over which the public has a right to pass and repass, and can be either a footpath, a bridleway, or a carriageway. When we consider the outdoor leisure map, this was submitted as part of the original evidence, and it is a map of the Blorwood-Swinscoe area. It shows the northern section of the route connecting to Slade House as a single broken line with green dots, and the southern section of the route connecting to Farwell Lane is two solid lines with a green broken line running along the line of the route. So the route is not shown the same in its entirety. So the key would suggest that the route is a public right-of-way, that the northern section of the route is depicted as a public path, that being a footpath or a bridleway, and the southern section of the route is depicted as a RUP, a road used as a public path. Typically, maps of this nature are not considered evidentially strong pieces of evidence on their own. At best, they can support the physical existence of a route. When we consider the tithe maps submitted with the application, tithe documents are solely concerned with identifying titheable land. They were not intended to establish or record public rights of way. The Blore tithe map shows a route running along the same line as the alleged route. The section from Farwell Lane heading in a northerly direction to approximately the halfway point of the alleged route is depicted on the map as a route separate from the adjacent land and coloured sienna. The route then continues as two broken lines, and the remainder of the route is uncoloured. This forms the northern section of the route. The route is braced to adjacent herediments 21 and 28. So the route is a continuous route, but it does appear to change in the way it is depicted halfway along the route. The information provided in the tithe award does not provide any evidence as to the nature of any rights over the alleged route. The Mayfield and Waterfall tithe maps show a route again running along the same line as the alleged route. The section of route from Farwell Lane heading in a northerly direction, again to approximately the halfway point of the route, is depicted on the map as a route separate from the adjacent land and coloured sienna. The route then continues again as two broken lines, but in this case the route does continue to be coloured. So the tithe maps support the physical existence of the route. There is a suggestion of possible higher rights over the route given the way they are depicted. What is not clear from the tithe evidence is whether the route was considered to have public or private higher rights over it. When we consider the 1910 Finance Act map, the 1910 Finance Act was concerned with mapping lands for the purposes of taxation. So the map shows a route running along part of the same line as the applied for route from Farwell Lane heading in a northerly direction. But as members will be able to see from the map, it is quite a small section of the applied for route that is shown on the map. So the fact that the route is shown separate from the adjacent land again may suggest that the route had higher rights over it. The route is unnumbered and it's uncoloured. However, there may be other reasons to explain the route's exclusion. Again, there is no clarity as to whether any rights are public or private. When we consider the OS maps do support the route's existence as a minor, unfenced or metalled road. At the time of the preparation of the first definitive map, parish surveys were produced to identify all routes that were considered to be public rights of way within an area. So a parish survey card has been obtained for a route numbered Waterhouses 1. The path has a path symbol of RP, so denoting a RUP. As members will have probably seen from the parish survey evidence, there is a lot of description in the parish survey card, and not all of the description actually relates to the specific route subject to this application. In parts, the route is described as a road, at other times it's described as a path. The Rights of Way survey plan does show the route with the annotation RP alongside it. So again, the fact that the route appears to be classified as a RUP would suggest that at the time of the parish survey evidence, the route was considered to be capable of being used by carriages and carts, but that it was predominantly used as a footpath or bridle way. Case law shows that even if a route has previously been classified as a RUP, this does not automatically mean that the route should be reclassified as a bridle way or with higher rights. The Section 53 process is about a discovery of evidence and considering all available evidence to ascertain the exact rights over a route. So at the time of the draft definitive map, there was an opportunity for people to object to any routes that were to be added or omitted from the definitive map. There was no evidence that any objections were put forward for the inclusion of public footpath 1A onto the definitive map as a public footpath. When we consider evidence provided by landowners, 3 landowners responded to the application, all raising concerns and objecting to the application. None of the landowners have put forward any evidence regarding the existence of any public rights over the applied for route. The landowners have raised concerns about safety and suitability, specifically regarding animal welfare, but as stated in the report, whilst it is not our intention to belittle any legitimate concerns raised, these issues cannot be taken into consideration when determining the application. In addition, Waterhouses Parish Council responded to the report, advising that they do not have any objections to the application. So when we consider the relevant legal tests to be considered with this application, what is not in dispute is the fact that the route is a public highway. The question relates to the nature of the public rights over it. The evidence needs to be considered on the balance of probabilities as to whether the evidence shows the existence of a restricted byway along the line of the applied for route, and therefore whether the current classification of the route as a footpath is wrong. To summarise, while some of the evidence is suggestive of higher rights over the route, when all the evidence is considered on the balance of probabilities, it is considered that the evidence is insufficient to conclude that the route is a restricted byway. Therefore, Officer's recommendation is to reject the application and for no order to be made to upgrade the route to a restricted byway. Thank you, and I'm happy to take any questions.
Thank you, Hannah. The breadth of evidence that you've covered there does show why it takes so long to do these applications. Any thoughts from members? Paul?
Just to support what Hannah said, really. Many individual pieces of evidence reported on. However, none of them collectively together shows that it was a public right-of-way. For that reason, really, and the balance of probabilities is insufficient to upgrade it, and so I'll go with Officer's recommendation. I'll propose that.
Okay, we've got a proposer, Paul, seconder David, and Jack. All those, okay, go with the officer's recommendation on that then, please.
Can I also thank Hannah for the quality of the research that's been done into that? I mean, well done, thank you.
Thank you. And staying in the same area, item number 6 is, again, Wildlife and Countryside Act 1981, an application to upgrade the public footpath 1B Waterhouses to a restricted byway from Slade House to Castern Lane. I presume that's Hannah again?
Yes, thank you, Chair, members. So this is an application to upgrade public footpath 1B in the parish of Waterhouses to a restricted byway, and also for the addition of a restricted byway between Waterhouses 1A and 1B. So the line of the route, which is current Waterhouses 1B, is marked A to B at Appendix B, and the line of the route applied for as an addition is marked C to D on the plan at Appendix B. So I'm sure members will have seen that there is a link between Waterhouses 1A and 1B, and a lot of the evidence submitted in both applications are quite similar. But I will deal with the application, the evidence specifically in relation to 1B, as well as what was considered for 1A, as they are two separate applications. So again, the application was submitted by Stafford Moorlands Bridleways Group, and it was submitted based on historical evidence. The evidence consisted of OS maps, Tithe Award evidence, and a rights of way survey plan. So again, if I start with the evidence, looking at the Tithe Award evidence, the Mayfield and Bloor tithe maps do not actually show Waterhouses 1B. The map only shows a route along the line of Waterhouses 1A. So where the route that depicts the route of 1A terminates in the north, the route is depicted in a way which suggests that it would continue past the point depicted on the tithe map, but this is not conclusive. The Elam tithe map shows part of Waterhouses 1B. The map does not show, however, a route running along the line of the route marked C to D. With the Elam tithe map, the route along the line of Waterhouses 1B is depicted as 2 broken lines and is numbered 71. On review of the award, the route is recorded as a lane. Also near to the route is the annotation to Colton. The annotation of a road to or from a named settlement is suggestive of public rights. Overall, the Elam tithe map does not support the route marked C to D applied for as an addition, and it does provide limited evidence as to the nature of any rights over the route marked A to B. Even if it could be said from the Bloor and Mayfield tithe maps that the route continues along the line of the alleged routes in the same manner as Waterhouses 1A is depicted, the route may be private, and therefore any vehicular rights could be of a private nature rather than public. When we consider the OS maps, the Ordnance Survey maps do provide some contradictory evidence, as some of the maps show the entirety of the route of Waterhouses 1B as a minor road, and some maps show part of the route as a minor road and part of the route as a footpath. Also, a number of the routes do not show the route in its entirety. However, we do have 2 maps that do show the entirety of Waterhouses 1B. At the northern end of the route where it connects to Caston Lane, the route does have the annotation BR written alongside it, which would suggest that it was considered to be a bridle road. These maps, so there is a suggestion that the route may have had bridleway rights over it, but there is no suggestion from the maps that the routes were used by vehicles specifically. We also have another OS map which does depict the route as a RUP. This map supports the route being capable of being used by vehicles, but that in practice it would mainly have been used as a footpath or bridleway. As previously stated, OS maps do not distinguish between public and private rights of way. When we considered the parish survey evidence at the time of the first draft definitive map, again, the parish survey card that was obtained for Waterhouses 1 has also been considered with this application, as what the evidence has shown and has brought to light is that previously Waterhouses 1A and 1B was one continuous route, that being Waterhouses 1. It was only when part of the route was subject to a public path diversion order that the 2 routes separated into 1A and 1B. And I will go back and discuss the diversion order shortly. So, as previously advised, a lot of description has been provided in the parish survey card for Waterhouses 1. Basically, the Rights of Way Survey Plan, which is dated 1954, does show a route running along the line of the routes marked A to B and also the addition C to D. So these routes have the annotations CRF1 and RP alongside. The plan also shows that the alleged routes connecting to what is now Waterhouses 1A. So, therefore, it was considered at the time of the draft definitive map that Waterhouses 1 was a road used as a public path. So, whilst these terms are useful, were useful as descriptors, neither had any legal standing, nor were suitable for the inclusion on the definitive map and statement. The description given in the parish survey card could be a description of the route rather than specifying the exact nature of the rights over the route. The fact, however, though, that a route is depicted on a draft definitive map as a RUP does carry some weight that a route was considered to have higher rights over it than a footpath, but this is not conclusive and therefore other evidence needs to be considered to establish the exact rights over the route. Again, as said with the previous application, there was an appeals process, and the County Council has found no evidence that any objections were made to the inclusion of the route on the definitive map as a public footpath. So if I just go back and just refer to the public path diversion order. So the diversion order relates specifically more to the route that's been applied for as an addition, so the route marked C to D. The Public Path Diversion Order was made under Section 119 of the Highways Act 1980, and it was confirmed in May 1992. So the order shows that a route with the status of a public footpath running along the line of the applied for route marked C to D has legally been extinguished, and the public footpath was diverted onto the line that forms the current southern section of public footpath 1B and where the route currently terminates on the definitive map. So this order is a legal document and no evidence has been put forward to question the validity of the order. Therefore, the order provides conclusive evidence that a route running along the line of the route C to D has legally been extinguished, and therefore public footpath rights cease to exist over this section of route. This application, however, is for a restricted byway, and therefore any higher rights do need to be considered. There is no clear evidence that higher rights than a footpath have been extinguished over the route referred to in the order. However, there is no clear evidence that the route has ever held higher public rights over it that would still exist. So again, when we consider the landowner evidence, one landowner responded to the application advising that there are stiles and gates along the route, but that the gates are never locked. They have advised that they have given horse riders permission to use the route. The Open Spaces, Ramblers Association and the Byways and Bridleways Trust all responded to the application, advising that although they had no evidence regarding the route, they did support the application. Waterhouses Parish Council also responded to this application, advising that they object to the application. The objection is based upon concerns over the risks to privacy of the landowner and the security of livestock. They also state that there does not appear to be an established connection between Waterhouses 1A and Waterhouses 1B. So as previously advised, only evidence relating to the existence and nature of any public rights over a route can be taken into consideration. So when we do consider the relevant legal tests, as there are 2 routes subject to this application, that being we have an application for an addition and an upgrade, there are 2 separate legal tests that need to be considered. So for the route marked A to B, which is just the upgrade of the existing public footpath, this application only needs to be considered based on the balance of probabilities, and so therefore whether on the balance of probabilities the route subsists as a restricted byway. In relation to the route marked C to D, as this is an addition, there are 2 tests. So again, the balance of probabilities test, but also this the evidence also can be considered as to whether the evidence is sufficient to show that it can be reasonably alleged that the route subsists as a restricted byway. So in relation to the evidence to upgrade Waterhouses 1B, whilst there is some evidence which is suggestive of the route being used historically by carts and carriages, there is no clear indication on the balance of probabilities that any higher rights over the route are public in nature. In relation to the route marked C to D, there is differing evidence as to the existence of this section of route, but what is clear is that footpath rights have legally been extinguished along this section of route due to the 1991 diversion order. There is no evidentially strong evidence to support the existence of this route or that it has public vehicular rights over it. Therefore, it is considered that the evidence is insufficient to show on a balance of probabilities or to reasonably allege that this route, this section of route should be added to the definitive map as a restricted byway. So just to conclude, it is Officer's recommendation that in relation to the section of route A to B, the evidence is insufficient and therefore an order should not be made to upgrade the route 1B to a restricted byway. An officer's recommendation in relation to route C to D is that no order should be made to add this route to the definitive map as a restricted byway. Thank you, and I'm happy to take any questions.
Thank you, Hannah. Again, a lot of work there on this application. Does anyone want to? David?
Only, Chairman, again, as you say, the evidence has been very, very clearly looked at. The office has done an excellent job on what we're looking at, and I think that in the base of their conclusions, I would move approval of the officer's recommendation.
Thank you for that. I've got an recommendation of approval proposed by David Smith, seconded by Jack Abrahams. So we'll take a vote on it. All those in favour of following the recommendation? Okay. We'll go with the officer's recommendation then. Thank you. Now, before we go on to the next item, I understand, Jack, you have to go at some point. Do you want to sit for this one? Because if you have... Okay, then fine. And because if you... Well, yeah. Quite simply, if you can't see the end of it, you won't be able to vote. So we'll go on, therefore, to application number 7. Again, Countryside and Wildlife Act 1981. And this is an application to add a restricted byway from Weeks, and I hope I've pronounced it properly, Barn, to Slade House, Grindon. Dare I ask you this? Thank you.
Thank you, Chair, members. This application is for the upgrade of existing public footpath 11 Grindon to a restricted byway and the addition of a restricted byway between public footpath 11 and public bridleway 10 Grindon. The line of the route can be seen at Appendix B. I can confirm that we have received no objections or representations from the local member. Moving to the recommendation, which is that the evidence discovered is sufficient to show that a restricted byway subsists on the balance of probabilities and that an order should be made to upgrade part of existing footpath 11 marked A to B, add a restricted byway between footpath 11 and bridleway 10 marked B to C, and upgrade part of bridleway 10 Grindon marked C to D to the definitive map and statement for the district of the Staffordshire Moorlands. This application is based upon historical evidence. In support of their application, the applicant submitted the deposited railway plan and book of reference for the Cauldron Low and Hartington Light Railway, dated 1898, the Grindon Tithe Map, Ordnance Survey Maps, correspondence from the County Surveyor dated May 1992, and a letter from the Department of Environment dated 1983. The deposited railway plans were created by railway companies for major projects and authorised by private acts of Parliament. Since 1838, these plans and their accompanying books of reference were required to be deposited with local public authorities. The deposited railway plan shows in plot number 7 two parallel dashed lines through the plot. The book of reference refers to and details this plot as Fields and Public Road, with the owner recorded as Frederick Haneker, Grindon Parish Council, Reverend George Daniel Rowlands Clark and Chairman, Leek Rural District Council, Joseph Shaw Clark. Within plot number 9 on the plan, this shows two dashed parallel lines with the description recorded as Field, Plantation, Road and Stream, with the owner recorded as Frederick Haneker, Grindon Parish Council and Leek Rural District Council. Both plots are therefore suggestive of a highway of some description. The reference to the district and parish council as owners of the plots suggests that they are responsible for its maintenance, providing strong evidence of the public rights over the claimed routes. Officers obtained further information regarding the plot identified as number 8 on the deposited railway plan, and this can be seen at Appendix K of the report. The plot refers to a railway structure, and the railway being carried over the plot, with the dimensions matching those of a public carriage road, as per the Railway Consolidation Act of 1845. This evidence suggests the claimed route may have higher rights than those currently recorded on the definitive map and statement, as there are no specified widths for railways to be carried over bridleways or footpaths. The Tithe Map and the Ordnance Survey Map do depict the claimed route as two parallel dashed lines, indicating a physical route on the ground at the time of the surveys. Whilst these maps do not clarify the legal status of the route, they do support its existence as it is recorded with the same depiction as that in the deposited railway plan. In terms of the other evidence, the handover map and the parish survey cards, although these later documents do not depict or record the routes existent, it does not detract from the probity of the evidence contained within the deposited railway account, which is supported by the Tithe Map and earlier Ordnance Survey maps. The legal maxim, once a highway, always a highway applies. Officers also considered the Natural England and the Commission for Rural Communities Act 2006, the NERC Act, regarding mechanically propelled vehicles, to consider if any high rights may subsist along the route. However, upon investigation, there is no evidence to suggest that these exceptions under Section 63 of the Act apply in this case. Upon consultation of the report, the Council carried out necessary checks online at the Land Registry and wrote to the named proprietor. It was only after this date, on the 23rd, in October 23, that the Council were contacted by the National Trust, who had acquired the land in September 23. They were not aware of the existing Section 53 application upon the purchase of the land and asked for an extension of time to investigate and analyse the evidence. Solicitors for the National Trust objected to the report and recommendation in March 2024, and a copy of this correspondence can be found appended to the report at Addendum 1 and 2. They argue that the evidence is insufficient to show that a restricted byway exists along the route. They contend that the Tithe Map does not confirm the route's carriageway status, and the Ordnance Survey Map only provides evidence of a track along the route. They argue it's highly unlikely that the claimed route was ever a public road, and the deposited railway plan and document do not conclusively show a public road. Reference has been made to the Finance Act plan, noting that the claim route is not included within the document, suggesting that the claim route would be identified as such in this survey. Following these comments and concerns that were raised, officers revisited the Staffordshire Records Office to further examine the deposited railway account, and this cemented the original findings. Officers' response to the comments made could be found at Addendum 3. In the absence of any evidence to the contrary, the deposited railway plan clearly indicates the route that is public, and that a bridge was built to carry the railway over the road with those dimensions of a public carriage road, and bridges were not built to carry footpaths or bridleways. The absence of the route's depiction in later evidence and its mere disuse do not extinguish these public rights, and therefore the public nature of the route remains intact. No new evidence has been provided to suggest that the way has ever been legally stopped up or extinguished, and as such, officers' recommendation remains. In terms of the legal test, there is an upgrade and an addition of a route to consider. The addition of the claimed route between existing public footpath 11 and Bridleway 10, Grindon, marked B to C, there is a two-stage test. That is, on the balance of probabilities, whether the route subsists or whether the route can be reasonably alleged to subsist. And in respect of the upgrade of part of existing public footpath 11 marked A to B and part of Bridleway 10 marked C to D, the legal test which must be satisfied before a modification order can be made is whether or not, on the balance of probabilities, the higher rights do subsist. In conclusion, the probity of the evidence from the deposited railway plan with reference to the public road, the dimensions of the structure of the railway over the road, together with the reference of the ownership being that of the parish and district council, considered alongside the depiction in the tithe map and the ordnance survey map, provides strong enough evidence to show, on a balance of probabilities, that the route is a public right-of-way with the status of a restricted byway. The route is shown in its entirety as one continuous route, and therefore officers also recommend that part of existing Bridleway 10, marked C to D on the map attached to Appendix B, is also upgraded as a restricted byway. The evidence satisfied the legal test on the balance of probabilities, and therefore officers recommend that the application be accepted and an order be made for the route in its entirety from point A through to D, with the status of restricted byway be added to the definitive mapping statement for the district of Staffordshire Moorlands. Officers further recommend that the route should be to a minimum width of 3 metres throughout its length. Thank you. I'm happy to take any questions.
Thank you for that. It's quite interesting that within the papers there are some later papers, and in particular I'm talking about the ones of the Highways Committee at the Borough Council, and there's actually members on there that I can remember, which is different than normally, because it's normally 200 years difference. I think it's Councillor Jebb's down there, David would remember as well. Paul.
I'd like to propose that we go with officer's recommendation. I mean, from the verbal and the written evidence, restricted byway to be upgraded. We add the restricted byway B to C, and we upgrade C to D with the minimum of 3 metres, as recommended by officers.
Thank you. So we've got a proposal and a seconder. Do you need to say anything, Jack? Okay, thank you. So we'll vote to go with the officer's recommendation. Unanimous. Okay, thank you so much for that report. Yet again, a solid, well-evidenced report for us. And we'll move on to item number 8, which is Wildlife and Countryside Act 1981, application to upgrade public footpath 14, Heathy Lee, Lapwing Lane to Coal Pit Lane to a bridleway. And this has been taken by... Oh, okay, carry on again. Thank you.
Thank you, Chair, members. This is an application to upgrade a public footpath 14, Heathy Lee, to a public bridleway. The application is supported by historical evidence. The application route can be seen marked A to B on the plan attached at Appendix B. I can confirm that no comments have been received from the local member. Turning to the evidence, the applicants submitted a Quarter Sessions highway stopping up order dated 1869 and an ordnance survey map dated 1890 in support of the application. The Quarter Session highway stopping up order, Appendix C, clearly refers to a claimed route known as Intake Lane and stops up the carriageway rights along the route, reserving bridleway and footpath rights. The supporting documents refer to the procedure that took place regarding the stopping up of the highway, and it clearly shows that the necessary legal procedures took place and were detailed and documented within the Quarter Sessions. The document identifies that both public footpath and bridleway rights were to remain over the claimed route known as Intake Lane. The Quarter Sessions order shows that although the highway was no longer suitable as a carriageway, that the bridleway and footpath rights over the highway were to be reserved. This is conclusive evidence as to the status of the claimed route in question. The Ordnance Survey map dated 1897 depicts parallel dash lines along the line of the application route, providing evidence that there was a route in existence on the ground at the time of the survey. And whilst they cannot clarify the status of the route, they do provide evidence of the physical existence of the features that they show on the ground. Obviously, this status is ratified by the evidence and the description of the application route in the Quarter Sessions order. Officers also sought copies of the parish survey card in relation to public footpath 14 Heathy Lee, wherein the lane was originally described as CRF 14, which would also support the contention of higher rights over the highway at the time of the survey. There has been no other evidence discovered or further legal orders to overturn the legal order and the decision that was reached within the 1869 Quarter Sessions order. Following the report being sent out on consultation, there have been no comments made from landowners regarding the report or the recommendation. The application is made under Section 53 3CI of the Wildlife and Countryside Act 1981, and the legal test to be considered is that on the balance of probabilities, whether it is more likely than not that the definitive map and statement is incorrect as it stands, and that the existing classification of route public footpath 14 Heathy Lee must remain unless or until the panel is of the view that the definitive map and statement is wrong. So in conclusion, the probity of the evidence from the Quarter Sessions order and the details contained within the highway stopping up order clearly retain the rights over the claimed route for bridleway and footpath use, and this legal order is conclusive. There is no evidence to suggest that the bridleway rights have been extinguished or stopped up. Therefore, officers consider that the evidence is sufficiently compelling to suggest that on the balance of probabilities, a public bridleway exists over the route marked A to B on the map attached at Appendix B, and that an order should be made to upgrade existing footpath 14 Heathy Lee to a public bridleway to the definitive map and statement. The width of the route should be 2 metres. Thank you. I'm happy to take any questions.
Sorry, could you just say what the width of the path should be what?
2 metres.
Again, fairly simple one.
I'll propose on the same reasons last time, really, A to B, upgrade from the footpath to a public bridleway, minimum of 2 metres.
Seconded by Jack. So, all in favour of going with the officer's recommendation? Okay, unanimous. Thank you so much for time and efforts put in by officers for this morning and the training previously. It's nice to see some of the things that we were talking about coming up in these applications and legal orders and such like. So thank you for that. I'm not aware that we've got any delegated... Oh, sorry, we have got delegated decisions. Item 9, which is S53 delegated decisions. Who's going to cover this one?
Chair, we weren't going to present that report. It was really just listing the applications where a delegated decision is made for members' information so that you can see that a decision has been made and what that decision was on that application.
Thank you. Now, David, I know that you're very interested in delegated decisions.
I'm just happy that we're recording them, Chairman.
Thank you. Okay, and we'll move on to exclusions of the public. I'm not aware of any exclusions. Okay, so we'll finish the meeting at 11:50 on the 9th of August. Thank you so much, and we'll see you next week. We've got another agenda, full agenda, so it's nice that you're using us now, and we're really getting on with the job and clearing that backlog. Thank you so much. See you soon. Thank you.